issues. Nafi, analyze it ruling and the Supreme Court ne buy. But Honorable Ebenezer Nina Nati, former MP Ablekuma Central, you will be good afternoon. Please tell Fifi one of his. Please, you should give me one of the good one. Lawyer Nana Eje Bafo Ewa Homane. So lawyer Akwabana apom to saying.
Nyame adom ne mobro no mi and I also want to say.
Nyame adom ye ho ye papa. And for the first time following Supreme Court case we probably the first time a court ni ruling na ewa pass ohwe how a Chief Justice to ne bo kan bibia na ewa kakra like the previous rulings no. Why was that? Is it because we in your first time a lawyers no argue chair but mostly the Supreme Court ruling be na brief and then no na emuwa the issue as take na unique and I been see there was a court ne dig here research be brede ba
me pacho me charity for them me say the uniqueness of the issue at stake me no me feel say the interest a generate here any senior na nipa bi mana yet say there sebi se court no makwan mama me na nkotena adaka mu na ekamiya ye se de sebi asede omofo bi boni bi so enti ohwe oti se nkrofo bi ka se in the interest of justice e bi so say constitution no making the electoral commission no accountable and enti e was so okotena adaka mu accountable for enti ohwe a court no decision no de opatri nyina ne se ye court o de ye de mra na ye adwuma na wo hwe mra ye de ye adwuma na bibisa na no mo peso mo ye ne mra ma ho kwan so enti no court no equal great length just say oko obo no ho modern peso wo kire say free 19 ko do ho say wo hwe ade a ye ne ye court mu dem ha se ya asempa ade no enya ade a ema kwan secondly so wo free kuruma kwa so ko nkuru bi so a sa ade no sabi bia mo pese ye no ye ma ho kwan enye sa na ye no so enti so pese de u pushi se ye sa de ne ma wa enyina so a u gina so se ye nsesa se ne si ye ne ma na nka ye ma maami nko ye ma isi no witness no nko adaka mu na onkudi adanse no wantumi ankyere the TSCS our constitution mu so akra wantumi refer to any constitutional provision a support to case abeka say in the interest of the constitution and not just said the court no person mo chair because omu say o mai mu ni nyina ye interest wo enti e was omuma ade ni mu pi na omuma ye hu abakosem ene sini yesi ye no nyina wo kuma say
and yes, court need at great length to make sure some bit church and seminary. But I'm not sure, sir, omutimi convince petitioners ni dear because petitioner and the council are indicated sir they might file for a review of sad decision, no, and yenim grounds upon which I'll be to me the review application at Supreme Court, the highest court of the land. Listening to a ruling, if we say Bibi Tochema womrem, a ruling in Manase a crojen.
Me pacho, I didn't say you were actually catering with me. He said, yes, I don't see whom rano. Be a yen so ye wunesa. Now, one say the answer na court no day. On decision
Ekosiisen on Asempa FM.
Emma me church won se mu bibre say ade na omupese court no ye no. Enye possible. So se court no make is Emma omu favorable decision na.
Asempa FM.
Enka enema bibre there will be a fundamental shift. Just say enema bibre beses e wo sebi ye mremu. Oh and Cassisi ubetumi court cry without a cause of action. Now if you court to them now will compel cause of action. Meanwhile, no answer now the court no I was only a cause of action. The patriot say
yes.
And Cassisi no so no cabit and a wunsun so be me say after ubetumi a court na afi no uni wase mu no Now we are a friend is saying, won't mean satisfy the burden. Now for the hopes that will be to me satisfy or burden, you know, and when the other side opens his case. So what I say, it would have it can cause a lot of fundamental shift, a lot of changes. It's a science what it through. I just say, I think you're not going to be seen tracing. So, and then ever down so import action other common law jurisdictions. So, now
Ekosiisen on
England, no witness statement. I have Fabia Becrume. Send your musi or moniema, original witness statement, also cry or moniema, yet you know, crab a dance watching or more dear. Me patroti ase ate se nka bema niema ye prekese so enti se wo call for reviewer na e wo se wo kire exceptional circumstance me patro de makeke de mebubu mu me patro na exceptional circumstance no eno no ehi na fa le bi free aba so what I say
yeah
ehi fa le bi free aba so
especially how detailed and not ruling it the authorities are your lordships SIT
settled practice or say the settled practice we should the decisions of the Supreme Court in the case of we should the decision of the court in the case of Harley versus Adra Farms or see a kromano and yema yina should be assembly yet training wo the render justice no a case law statute. So,
yes.
any a friend is saying the settled practice of the courts under the rules of courts. The patriotic say the settled practice of the court. Here the settled practice of the court. Settled practice of the court. And near my choir, your fashion, your near my yen if you be nimro. And then the settled practice of the court. So, a team put also person can say witness statement no crown a for frabanti a developer rules no. Actually, and sing senior Niama. So, in the input to say the Onua Kutu England for CPR, that is the English, the Civil Procedural Rules of England, 1998. A civil witness statement to free by, you know. And also, Charles said, no, witness statement to file here. And on Chelsea change as all Quadakem. It just on all fours, maybe actually beyond the Supreme Court was right. And now, one, yeah, not the Biame was in Biameka. Oh, when you know the law, you cite it, right? But when you understand the philosophy behind the law, you articulate it. Embrano sebi, and yet Embrano nene sometimes the uhuno ocean or red, a friend say, ya type on a black so the understanding behind the law, the philosophy behind the law, the reason behind the law, and it is witness statement, yes, the rules we proceed, the anato, the patrol, a chile wasem, a chila some the rules of evidence, you know. They or carry the burden. Time at the burden of proof never shifted. Me patriotic I say. The burden of proof no. Ya man conformity won't say burden of proof no. Oh, burden of proof no. And sabi uko quarter one make allegation. Ya me so na carry the burden. Burden ye di asem na to the be it me shifted. Eko baby. Na asa shifted aba.
Yeah.
Me patriotic I say. Enti ewo with the reason behind it, or the philosophy behind it. So, and you say, well, what track a case are? It's a what track a case are? Over cite, you just cite the law and think that that is the right proposition of the law. But, so what say, none the way chili as someone, oh, you just don't cite it, but you articulate it.
Ekosiisen on Asempa
FM. The other thing is, baby, I do see no. Now you name say petitioner no a close in the case, but as we speak, Oma file a motion at the Supreme Court. Say court never won quite no reopen case no ebio. Is it normal practice?
Oh, me pacho. Yenyamwa asebno nko ade. Me pacho obetumi apply. Nemu me se si a wa close case ne de. E wo se wo kire court ne say. Wo se wo kire court ne say. BNT a obese European case no. E se wo kire court no. We say we litigation must come to an end.
Yeah.
Yentra court to them affable. And in fear to pay. So, in order 112 of the civil procedure rules, a bachelor will say, "Oh, a dear decision be a court to be making. I also taking into account the need to avoid costs, expeditious determination of the matter." So, what I say, any friend is saying delays, so avoid the delays from me there. So, what I say. And only the overriding principle a guiding man's chain where in court to them. So, in Tisa, what close case, what we choose what close case. Nasa wo basi open case ni biwa. And was so which saying here, she say no open case, you know. So, she say no open case, and she say offer another witness. So, a drama whole quine, name no, and was so which say, one. The entire friend witness, no. So, two, as a witness neighbor cannot the relevance to the matter at hand. Not a tosomians. What should I say? Answer now will be close to case, and answer now will do case, and be very, you know. So, at the crowd will friend witness, and I'm gonna become 170. A idea be a master, a dance be a friend, I'm gonna be a document be a friend, I'm gonna betend that. Na sabre no asade kro no hwehwa na ya de bia obo wo mode se wo hwehwe nanso wo hwehwe ye na uguda and because upon a diligent search you could not find it. So what I say,
yes,
and was so what it's going to be a very big hurdle for them.
It is here no two hurdles because even on seeking the leave of the court, say if I see a sign be a case ni bio no. I was so convinced the court no why I was on my crying na ubie case ni be number one. And ubie we are because of my indicator or any motion ni say the subpoena documents na are ready as a court ni grant you on leave to reopen their case and they would serve the subpoena document no on the court. Enti so almost service as subpoena document na no so no I was a court ni mo kwan sana the electoral commission.
The subpoena ni o filing the registry are serving to the mokasa are ready to momo kwanya on be survey.
On be survey. Okay.
But essence about close to a case in Tino. A one of the Supreme Court the entire and we hear say omo kwanya no case. So Fabrino court no exercise discretion, but omo discretion they exercise judicial the friends say judicially. Which is that I see you know they say to minimum so ma kwan na offer a witness. So minimum no say to you know say or exercise to say to you na emra e wo kwan a faswa e wo say or exercise
FM.
E pa chotia.
Yes.
Into wo court to no o ko akos
Asempa FM.
Wa application na wo dia ba no you are with wo Niema emra ekase court to nenshe ansa na wa grant sa application no why day what satisfies niema no the part what I say intino eno na sisi omo kwa akọchire de no na me ka kire wo say wa close ni case into wa close ni case no aye sa niema we na okwa akọ into say one relevance issue no asa beba up because I was always say idea wo frɛ nipa no amana beka here. So
okay,
the same burden o satisfy under the same burden o satisfy under the same burden na ehu here say o satisfy with the interrogatory. The same bed na we answer or satisfied with the discoveries, you know. A better UTBU.
The relevance will come back.
Relevance will come back.
Wow. Wow.
Ekosiisen on Asempa FM.
Say, sa information na o maame ne beka ho asem no enya de awo nso sa information o ho bie. It's in the exclusive preserve of the it's in the exclusive custody of the Electoral Commission. Just say Electoral Commission ko na sa asem no bitimi aka ho asem. Wo de nka wuntimi nka ho asem. Me pass what I say.
Into the attorney say the argument was a counsel for the petitioner, lawyer Tajuji Kata Eye, to seek the leave of the court so person mo reopen on case no. A very different from argument last Monday no mo ye.
They completely different.
Oh, okay.
Sonkokra.
Indeed, the argument in opposition to your friend is saying to counsel for second respondent say omo makwai omo witness manage na bo because ni nyina na a matter of getting the witness into the box. Into argument our year Monday no why will it be different from the obey no nyame ya adomo 15th said the court no ashe no
see at the said dia wo dey go to court na ni no yes from kon enye at the said dia wo dey to na ni Monday no enye the same at the said dia na wo dey go to court na ni ene
Ekosiisen on Asempa FM
na etosu ni time so a okoye ebra wo dey sa the said dia na court na ni no eye breso eye brefofro ebre no ni say eye bra wo close case
yeah
le patriote I say it is a workers work close case there na fi the MO open case
ama wa open case no
she says no le patriote you enye ono nko na close case o respondent ni so close o mu case le patriote I say
yeah me too
court na ma orders say omo file omo written addresses by Monday. In the court case, we are close case. No court no to an amount at the atimu ababonte. It's a court need to an amount the atimu ababonte. What the court let's have college. The patriotic say, I may refer to order 1 of the civil procedure rules. The patriotic say,
yeah,
say, we share order 1 of the civil high court civil procedure rules now. And claim delays Emma and the entry so Emma and when saying a couple beer so your day Emma so and into ocean is
Ekosiisen on Asempa FM
say zero one say you said the air chill what the castle back to say a dear ma no beside the castle
but how about because lawyer Sami Jemfi a post way about 2 hours ago or say the petitioner closed his case on the basis of the clear indication that Jean Mensah was going to testify. If despite filing a witness statement and what is in her affidavit, she now says she is not testifying and the court says that's okay, then the petitioner is entirely within his rights to ask the court for leave to reopen his case and use the subpoena route.
Me pacho em say to the bia na nyema bia e
Asempa FM.
So court ni mo a udi at the thread ye na eko. Me pacho ti say court no so e de mra na ye adwuma.
Yes.
At the thread bia wo de to court na nim no e principles be in a govern court no. Into court no most of the between
Ekosiisen on Asempa FM.
Answer court be bua at a bua assembly. Application here what the court to no. So long as the court make a decision on it, emphasis and your friend interlocutory decisions. So I said, most interlocutory decisions, most interlocutory applications and decisions of the court, are discretionary. So I said,
yeah.
But court not discretion or exercise here, and which also the exercising discretion but what I say, it is our discretion, so who exercises our discretion now. Oh, court court or exercises our discretion in Mawa. And was so the a senator say, as some pempen so I would decide this the DNA down court no. It just exercises our discretion here then a mawo. The patriotic say it application a air queen no one instance court no also say the exercise of the court's discretion. So
Okay.
It enye a say chinchina mama no ama media dance here dia and was support no ma kwai na wo frɛ no.
Ekosiisen on Asempa FM.
One here that will be between the application as young president coming media here of a yambra and a guided media.
Yeah, because already no respondents now my indication say if the subpoena application go through or Monso might seek leave of the court to reopen their cases and also compel the petitioner and Kasa to also come into the witness box.
Into one say the court in exercising its discretion now will have some of these things at the back of its mind. Say he need diagram case no yeda. Me part of the make out say. Even though it might not be one of the principles court to making a decision, but said a bit near way because almost that is a tool in me part of me part of what I say. That discretion here will copy and who are money and who are quanchre wo and wo mrem into wo court name no sa and who are money and who are quanchre and I will quanchre court and say what sa and who are money and quanchre no also sa now fata say why they ye bi bawo me part what I say.
Yes.
Say no offer omo application na
Ekosiisen on Asempa FM.
Say it kind Dientina omo pese ya fema amiji mensa. Is it relevant? Two, say irrelevant. The second question then say at the compese ma me beka ho asem no. Oh, e ya dia ma me pe e betimi aka ho asem. E ba what you say. E ya ma me pe ne betimi aka ho asem. Say ya ma me pe ne betimi ma me pe mpo ne betimi aka ho asem. Then the next header will be ansana parties need to be close to a case, So na a friend is saying a idea na omun to me end. So if you want to be a summit and post out the other two way, a one other friend say, yeah, has a man or the baby dear dance here, but one man be dear dance and as I say, I could hear say a friend. So what I say, no, ansana will be true honor. And we so to satisfy near my medical then I can't watch them. So some of the principles will go back to the interrogatories and the discoveries. So to the next one I say, it is dear now piece will be son, near my piece will be son and here. A crucial questions are never interrogatories, for instance, the dear transmitted results on a fire. Right?
Yes.
See who are you be transmitted results from the fire, will it affect the results of the election? That's what I say. Secondly, petitioners also say, respondents also say, some of the questions in our interrogatories, they had already answered them in their responses.
In their answers to the petition.
Exactly. It is said to say, if your man is about to come once in you. That's what I say.
Yes. Yes. Enti yebetwen Monday already court no ashe say yes, despite indication a lawyer Chachuma say omo some two applications bi on person omo de ba no. Court na ashe say still omo written submissions na ready by the 17th of February. Na 18th omo nyina mra court na omo memma highlight of formal written submissions no viva voce into obi ansori na onka na court no ente ansa na court na time omo de omo ruling ebeba with this strict timeline no any applications as you see a petition and the ba no basically they play out
say okay ma play out so far juma let's just say I was when the court in the timelines no so that's what I said. We say, okay, Sabria, a bribia, almost filing for review.
Yes.
Court no insist say, now Oma making orders. Say, Omo file, Omo witness statement. It is someone file a witness statement there, they will not hear them. If I talk, it is so what the that is the friend is saying. That is the recent precedent and a play out in this case. Not just by Monday now, court on the Bebano. Not just was all my file on my address.
No, I think that the deadline for the address is 17th. Which, 17th, yeah, which will be Wednesday.
My file on my address. So the only difference is that say file address, not say court no a grant to application. Then subsequently you file a supplementary address.
Yeah.
So until it make a difference, yeah.
Oh, okay. In your file address, no, by the 17th, no. That's according to the court, 18th, no, but my highlights of the addresses now.
Ekosiisen on FM.
Applications for fra air coin na no korea. Court ni betima mo kan mo file supplementary address.
Me sure say by 18th, no. Court will be you or more answer or mama highlights,
no, okay.
But then it was her address, now I then what file. So
okay, yeah.
By 18th, that's a court to 8 application or grant here. Then obit me my witness, I call witness box. It's all called witness box no file a supplementary address. Then I'm sure some them further direction from there.
Okay. Yo, lawyer, the best, but it's looking like court no a granted application for the petitioner to reopen the case. Now, Mama crime a subpoena needs to go through then this case is not ending anytime soon.
But court any determination to bring the matter to an end. Also, what timeline is strict bar. It me sure says subpoena no crown. And you be a check. May we give you when say acha
Ekosiisen on FM.
Yeah. Okay. Lawyer, my fancy bibia ni a ye besia baba ka bedi nkomo. Why? Yeah, that's a lawyer Nana. Great. A J Bafo Ewua or a private legal practitioner and I'm in Kano. Ekosiisen in a higher Sempa FM or Argentra, but more than so would be brain 0546382287 or call you in Facebook page and so ubet me the comment no ego on Facebook, on YouTube and afi on Instagram and Twitter. Still, I any lawyers no being subedin command this time no. Ye beko spokespersons ne ho na afi yetie omonso anyhow anioma esiko court and what it means to the case going forward. Agbave Herbal Center some infantoma name say yesrem wani die mu a say wonsanka mona soap any mona cream ne bia bomodin ne pebi opesa wo hona metoso kama unwi efu kama mona soap odi dware now the mona cream ne nso asra bibia beko yi kama ye wo agbave fever and also no, to fight the onset and the outset of malaria. And you agbave tonic na fi agbave balm. The vajo tonic no ye nuanum ma modie no or suffer from menstrual clotted blood flow, Flemish menses, black menses, piles, ni nyina wonum bia ebeko. And a balm nenso ho ema pompon abo honami tutu de faswa ebeko. Agbave Herbal Center ye wo wire is a fee. One number ye 0246 595256. Insuo so yin na yaji atum say yebenom Awake purified drinking water Casapreco Company Limited wonsuo enono Casapreco Company Limited insuo my idea bejaso enono and you different sizes into 330 ml and we know insuo na ne tino or bottle no etino and you can also say in green lemon green inti uhu a ubi hu stand out unya bia papa you 330 ml 500 ml you 750 ml and a 1.5 liter yasia here special 19 liters jar and no disi office and as ufia bibia ekoye ede ema Awake purified drinking water oto ye bottle ba kubia ye yiska ni be de boye nuanum e National Cardiothoracic Center ewo kolebu na omo a be heart transplant omo hia surgery ne ade no omo atimi dia ye open do etu afre kasa preko ewo 0262 351 251 ye kwa homa ne so akwasha ase di nkomo. We start with spokespersons for the second respondent and another dankwa kofuado. One of the spokespersons, Information Minister Designate, an MP for Fuasia Yerebi, the Honorable Kojo Opon Nkrumah, or say a lawyer ni lawyer akwaba na pom te saying.
Yamiadom Obi now so.
Yamiadom Yahoye Papa. And Supreme Court Tonebo Ekasache explaining the reasoning behind Omu ruling and for more second petitioner no. More satisfied.
Second respondent.
Hey, Mr. Petitioner, I asked more facha me. Second respondent, no, more satisfied with what happened in our court.
Me kwacho it can be charity for Madawase Akwenya Odi Amame. Na maka say senka Supreme Court ruling no. Senkomba no mo kan say emra no say na ti ne mmom ye mfa nye adwuma no na nkebe wawa. Because the Supreme Court and the Supreme Court speaking through His Lordship the Chief Justice. The law is settled. The party cannot be compelled to adduce evidence in circumstances like this. Emradada edaho fitim resantia yadia tumwa ensisan and say. Ni awudina bidina court no wun to me emma court in shanikete say yemfanum bidina dekem na umbidia dance yemau. The law is settled that a party cannot be compelled to adduce evidence in circumstances like this. Now Supreme Court eto nebuase ekoyi authorities from various years, be a high court, be a court of appeals, be a Supreme Court, decisions are same way abba omanimo makante da to Nyamiche versus Ansa, Bamo versus Labi, Tay and another, Amma versus Hydrophone Estate, Society of Lawyers, cases bibri wa ubidina sama ba when huna samaka. No, we are court and share Nipana deno Nipana or sama no court and share on Yamfan bidina adakanim no near dancing femwa or no de Nipakona by and no quadruple for no court and share nipa osama no so on fanamra now umbidina box nobody dance and work with before na court they be on the Asamba court different people they are court and your lawyer for bona bro free or mu twa mu sa come chasa we are court na catch us emra na sanity webu sabe emra ni kum nti no ni asema court in the court na san kaka obium say a case is won on the strength of the plaintiff's arguments and not the weaknesses of the defendant. Say ubebu bi kwedu ewo court a wo wasem no nyina so ene wadanse a ode bae no ne hwesu di bu asem no na enye se nipa ubebo no kwedu no so kan bia na se wanka bi so no ni case no krampo when hunu na asem ka se wo wade a ode bae ne se mu nye du enkyere wasem no endum pempen so a court ne review ye mu emma wo. So see, a case is won on the strength of the plaintiff's arguments and not the weaknesses of the defendant. And some of the autosomy and court in the case say what in your nominee force. So much more can say a constitutional organization. Now, by penning or occupy a constitutional office until still holding accountable. Now there are questions that she is the only person who can answer. Court in the same. The fact that there are constitutional responsibilities does not mean a different set of rules should be made up for her. I'm passing a constitutional office. But Obana Obesamina, Emrana, Yede, Eye Juma will court them. Yen Yemrafufro, because also a constitutional office would Embrada Danet down and 1 year the bedroom. And then a man the basa. Every John Dramani Mahama, Ghana former president, any two abayi or say. Abane 2 years. In fact, time obedu court no just be en win. First no the castle no win. Obedu court also be en win. Na court say, "For dance before num na also won't be prove no." Na fa betre. First person or by general, I see do ketia. Obeka na asem, e calculator share nsa obo wie no. Na John Mahama nya 47 na Nado nya 51.2. O di teaching man kan we fee. Anado 51.2 to Mahama 47. And we see from on the second witness by Dr. Kwesa White. Or no by nan could be a few, so no will be proved to be a winner banner. Or no by no. That's some of the buy and say, this boss no instructor and it's own PMC. Only a design and so only the Casa said there be designs of carbon of fast instructor or see Roger Metal the catcher and say, my minister of Monco. So much on laptop or only again on core.
Ekosiisen
On Cofa Roger Metal by Roger by first or send home financial bear the testimony from me baby or one man acquires on your testimony. No, you know, a testimony be. As a man, Roger Becker and he said, pink sheet, summary sheet not signed yet. Baby, or why he signed in error. Now, a problem was, but or sign be. Now, about penny no and a pamo mom, sir, or monko. What's a result? No one can answer. And to the extent that just now, many will be trying to say, you know, at the point, cry, who feel, when you so few, who what my main office reception. Now, woman, TV biscuit, the coffee, and baby, at the assembly at the back or so. If you are witnesses, me and family. Now, some of the back court to say, will be a winning and court about before. Witnesses no. The back court to me approve the media court and be determined.
Yeah, but almost because of the new rules of engagement, what is in the witness statement, unlike before, lawyer for will lead their witnesses to give evidence in chief, no. Sisi and bibi our matro, and for see doing ketia, for example, no. What true or more issues ni na numbers ni bibi on a witness statement mo which the court is seized with, and even though one kind the box no that evidence is with the court.
No problem. Obi himself
Ekosiisen on Asempa
himself
FM.
can see doing ketia witness statement. But over to me actually media.
Asempa
Or
FM.
can woman court ni seized with IBA one count about
The fact say numbers no s a sign bebre omu nim your friend is saying the total valid vote cast any other and my instances where our numbers need changing and they think the EC has some questions to answer relative to
but court now
Sorry.
by yes you think so be your questions to answer. But now the dance yaba. Who should be in think I was check out no why a mass no what train so be in with it. But if we na the omu na hwe. You will say don't get your buy when to be witness statement will be any baby I watch it any Rojo buy sa a honor one can announce it to court and so maybe case no. Until I done on my car says and phone, be taking notice that they have formally announced to the court that they have closed their case.
yes.
Maybe our own lawyers had their own shutdown senior here. Sa formal prayer no who prayed to court now let's say what to phone him what is Safwana Loki say massem no. Menina so am de buy any again na evidence am de buy na me prove ni le with my locking me closing my case. Until first respondent the lawyer just na me was sorry no say my lord yes we are closing the case any evidence for be adema and a second respondent to say my lord yes we are closing it they say a pomi and sunny na yatum a hona yere chachuchi kata say there be a ma court ne my kwan ma yen 2 year pon ni mo je say ya frɛ yɛn witnesses about adan I say the fact say file a witness statement which say we have made an election say yɛbɛkɔ box nim. Secondly, ECD or no file a affidavit in opposition time application for interrogatories no buy the affidavit in opposition no can cry evidence and so now this third argument of constitutional rule and then a court no buy say first of all a court in a ma order so be and file a witness statement case management near my file and constitute evidence. Court in the car say will be filing the no cry no yen no men this for you Mahama lawyer for man ye court time ma umdafu for so mon yansa na umbe the fact of my filing witness statement and say one more elected so mo be adduce evidence. Number 2, affidavit in opposition now about during interrogatories no and yet evidence in the substantive trial. And then number 3, it's also a constitutional officer over hand that is Article 64(1) election petition.
Yes.
Mandate near limited. And tinya hana sebi ukwa kofa nsemi na abase isi membi yo manu in general accountability platform there with the court nanka me na make accountability platform there bra parliament hona ibitumi aye parliamentary inquiry ne afre no abe church ni nsemu nyina ho ba court de okona akosama na mra kan nti court no ebua se ampa ono watu ni pon waka na asem na wi se na asem na nyina so de ba nyina we wa lucky first respondents we need they were lucky second respondent when they were okay. She say aso se court no be bu asem no. The court ahye se wukuada obi amfa ne written addresses emra. We did say the baby on be fixed data.
Omode judgment never ba.
And no na Yura Mahama lawyer for say one the application for base. Ye mo kwan no munku biom case no so for.
In fact, omode akoda da o. Yes, we omode
who say 37 pages so say.
No, 37 paragraphs.
No, from what I saw, it appeared to be.
No, also they've attached the original petition as an exhibit.
Okay.
To this, in the Nama Ados, no,
okay. At the time, I near court, no more 7 say, or mobile filing. We are penny and pie and TSA or more filing. Copy, I mean, who are 1/37, turn and make us a better page.
Okay.
Now, almost 7 say, yeah, mom, quite no more view of case no control.
FM.
Now, I don't know, Emremuno, there was standard also with it. Say because the old one could don't go court to I view. Yes, okay, I know I can some try. Baby says, and I'm running the same. I was walking down on Brano, then the original so I would cancel it. Into a legal threshold, I was a umiti. Fina or mobile commerce and my or mumity. Yes, your lawyer was very pliable. But and stop or 7 casa from moving forward. Into baby, any. You're a Mahama and a lawyer for some commerce maybe. Easy I can't deal with, yeah, I can't deal with. I'm Kayababi Buasemano. I'm sure mom to me no could be asked so for. Na me did say yes, your lawyer for qua, or mother befitting response for it. Send a can of Titanosan to us to say, as in the anyhow. I buy a toya more and pipe from Moki figures in the boom. TV3 for Kika boom, Metro for Kika boom, GT for Kika boom, PCFM for Kika boom, PN 4751.2 near Chile. Yura Mahama Kwa, and also in arithmetic near different kaka. Or bar court or so no. We closing the case, we know, or to him improve. You see, and some man quite many be the case no. Non so bit to me the evidence, maybe I can home and approve. It is a court in some. At any material moment, you have court, Ghana phone will be on, and I don't go to wedding with over 500,000 votes match.
So courts no a grant won't leave to reopen their case because I'm indicating paragraph 18 of any motion. Once the court grants them leave or more subpoena documents are ready, I know so or more prepared to serve. And the court almost are to reopen their case. And doesn't it change the dynamics of this whole issue?
No, at all material moments, they are a 7 on the career back. A dance a bois a arithmetic. The baby we mass. The make a can numbers in our boom. Neighbors say, Nipa declared as president elect, no. Not a correct declaration, I say a declaration. Also a declaration, no, Minchro BB. Nipa obey declaration, obey to me a start here for them cry. Bet me a Kikagana back or 7 and kick on there. Wabo bon numbers na win ya see na would you be can one obey us analysis me na ni nan carry. We are no akase. By the powers in me vested as returning officer, no, I hereby declare Osebo so Philip as the president elect and only declaration. Is that declaration valid? It is also issue now, court ni frame me or say data now or their declaration.
Ekosiisen
okay, does it make the declaration valid or not valid? It's a whole banal case. Now, not for me. No, for me. It doesn't affect the data now. No, baby, but under Article 64, and then we are court number in our hint. Starting and also we are here under Article 64.1.
Yes.
That's challenge to the validity of a presidential election. And yet, constitutional accountability assessment rules are different. These are all the constitutional accountability assessment by because what buy no Article 64.1 now they buy. Now you say under Article 64.1 at any material moment, if you prove that and now do more than 51%. Then it is mpo asem count mpo. The court case o mama no kwan ma be in case for.
FM.
Na san court case was sama no kwan say o supini no supini a e ba be gina ho a mass na na e be and mass no e change. And we are 1. But number 2, the legal thresholds even to reopen a case and adduce fresh evidence are very high. Very high. When you hear an actual money again, authorities will. The choir about my say bill case, Nasan Bay, your friend is saying new evidence, very high threshold. and son a coin a bema coin say be subpoena and also a very high threshold. And the court a catch or say
Ekosiisen on Asempa FM.
We are making sabi Mr. Manusi Sumana Sona Maker. Me can any dim and yes, I may candidate trial penny biampoa. I didn't say they went to a court or say the law is settled that a party cannot be compelled to adduce evidence. Subpoena near that. Say court in the Pacoma named adduce evidence. Then you're not court in the catcher when they say the law is settled on that matter. But meaning maybe there's a part of the law we haven't exercised our minds to. Into your beshe, a horno seniate. But baby, you didn't idea, and Brano seni limno, and on a court no a day Juma senia etino.
Sir, in the case of the subpoena, maybe now the petitioner can convince the court questions are relevant to this case and to the delivery of justice. The issue of relevance might come back. Yes, even though we in him say a settled law, so won't mean compel you be evidence. But if
I know under the subpoena side or no. And the subpoena side or no, the question I mean the legal threshold now yes. Relevance in common.
Okay.
And your relevance in common. The conditions under which a Bema find more issue subpoena. The conditions are there. The threshold is very high. Conditions under reopening of case to adduce fresh evidence. And also the threshold for and then I kasa you see the penny temo yeah asama can say sabi in fact in penny for busa beno udi kan wo court wa na nkyere say udipem. The fact say una udi kan wo court no nkyere say udipem penny for twi baby say kasa tintin and top ponko court oni itina no sabi enya do woni mu am penny for ani mu a me nka mu penny bia ni mutia because penny for lawyer pon penny for nyina ye buom ye nyina ye pese da chi bi ni be lawyer pon penny for te so omo but court oni itina no enye kasa tintin no ena enye sabi ukan twa ho da no te say ye lawyer ba ko kasa omo argument no e secretariat e secular e twa no e kwa na ba biti de ke kwa na ba biti de chi in fact the court na can say you have cited no authority to convince us on this constitutional argument you are making. Just say law be any wakasa but authority, uncite authority be arrested. In fact, so what you ruling now say this court does not know of any law. And if any law such exists, we dare say it doesn't apply in this case. And you mean American no be akase because you come penny be any Intenye kasa no ne yi akomni ntwaho no nye no eye law no se asem na wo ka no enyina mmara no so a court no ya adwen a enyi nti yan asem no de nye tinkin bia
my final question
mpacho answer na be ko say Ghana for now say and is for us so ma no prensa eya na nkofo we fe ma so ma no prensa e kind of so me wi Omo percentage, I'm say 51 point something. Ome winning. We took on the boy. The videos in our court. And no nama NDC supporters. No, wouldn't say NDC supporters do one day. Omo GD said they won the election because of their omo penny for catcher up. Omo crowd omo new part now. Omo be court say obi en winning no. And omo binom send omo time. Oba penny jimen say ni some omo trofa no ho social media ni ade no. So also say or requested for security protection and ya dia obi abejeja na musa ye no to nche omba court no must say ma no say okay obi enwe ni eno ne say omumpubu a aye den ama omi in the last one we come say ma no biom say den cry nya about obi enya 50% about constitutional body was or ye accountable no render account uti
Ekosiisen on
Asempa who can say a constitutional case na mo start fee when winning I feel when winning I feel we change the constitutional case and the court na catch and say 64-1 mandate na limited ye nkonko ne nam constitution fitiri bia say emra na de ye adwuma e wo court dem ha say wo sama will be approved what sem ye nko yanim no eno na de ye adwuma
Asempa FM
and it is ade was NDC supporters me nuanom ma mante mebu a na omo gidi a omo panimfo ne catch omo adi no e ade also omo start a shining omo ani say omo panimfo na dada from the beginning omo we need to now omo be we need to ne in the last 1 week omo say some no say enye calculation na sem na ye constitutional accountability question na ye kan we NDC supporter or so shiny when you know who said penny for another down.
The final question is, and I don't know, Supreme Court reference to the facts as far as any ruling here concerned. No more reference. A petitioner would win the case on the strength of their own case and not on the weakness of opponent in the case. No, na a orbiter na say a ratio and kasa for which reason Obibeka say na say court no e kasa because petitioners no e oppose application from first respondent lawyer. Say omudi omunyaya nko omma omo witness image na box ne mo no menyini say petitioner ne ka say they will need the woman to come because omo case omo de ba court no e weak and omo ntimi improve omo case. Inti why would the court make that point?
In all honesty, media and Kamefan say eno ye orbiter.
Okay.
But orbiter enye mogu orbiter tell baby a court no na dwentre. Ratio decidendi, the reason for the decision.
Yes.
There were 3 grounds that were advanced by the petitioner. Bakone say, or no, Susun said the EC has already elected to adduce evidence. The ratio a court mind that you say, a order na court ni ye and a parties follow ye. So you cannot interpret that to mean election. Election here when obi any case and obi decide obi elect se me box no na menko affidavit or ma ratio no clearly say affidavit no enye evidence in the substantive matter. Affidavit during the interlocutory application no enye evidence in the substantive matter. And so a constitutional rule no sanitary say there's no law cited that is backing that one. But we yes or ye orbiter say where ye can say more e wo ubebo kwedu before what seven na holding so nyina edibua. So a case is won on the strength of the plaintiff and not on the weakness of the defendant's arguments. And media, I consider that one as orbiter. But orbiter, you can't disregard orbiter. Orbiter chereo, of course, it's not the ratio decidendi, but a chereo baby a court no adding a chere. A chereo and near my court may consider in making its decisions. Inti se wusi wu make you case. Now we train this year day. Easy about penny with now that can and son of what you mean your case be a make here. I told you why.
And that by extension will mean say court not dream no up to now petitioner still ain't making the case yeah.
And yes a court not dream petitioner nankasa na one notify court and say making the case yeah. When you make an application to reopen your case, what you are indirectly telling the court say, are there now see why you were close you know. In Pempenso ananke wasn't kaudu. And until now, Nanka, why we are meeting threshold now? Why are you bringing this application to reopen?
No, sir, the application to reopen came after the ruling. The court said that before the decision for reopening.
We are saying the same thing. We know the same thing. We say at the time I will announce it to court, so we're closing case. So be enforceable. And court and order also closing case. You close your case when you know, say, evidence are who hear their case, now why you go. Evidence are who hear, witnesses are who hear near dinner, well leaning now before the court to the extent to say, I feel the person on the other side, no burden of proof not shifted. So I'm sorry, I'm between that kind of defending one. I say, no, ube di bim or no be for. My example, may my back court to say, Sebe, Obi atomemona. Me na me the prosecutor. Me na me dey asem na back court say obi ato. We say mona. Me ba. O say me kire hwan na ato no mona. Eto no mona we hwan na to sa mona. Medical report I kire e was a victim no cramply bia me pa me ni betina box ni mu. No no aka na enu masem na say da na makofa ne doctor aba. It made the expert witnesses by kika ho. By the time I me wie no na ma bow charge at the advance here at the documentary evidence near the nyina egu ho a judge not to no the trimu nyina to nyina say na branti pa ade no to geli mo na ade no yesa two bones say abre no burden of proof no a shift so what now say why you think you ma
Simpa FM
udi agora ye do betum obi an toof one na be so rabegina box no so my lord Mr. so kasa mato no mo na enye no kre ebia oye me ho kafo a me ne no wo ho na sada no krampo no say ni me text message ni me we ni nti dia all kan enye no kre ho na call because oh okay any burden shifty better also no and sustainable. So better now to papa so say my lord na manumbi and an kick down there na shift better also that o consa no inti on the panel or make allegation no or no burden of proof no done so say be prove at the end. We require a balance of probabilities, but in a case like this, we share the thing they are particularizing now. I dare say a better above balance of probabilities, a better proof beyond the reasonable doubt.
Oh, really?
Oh, yes.
For which of the issues? For which of the issues?
Now, you see, for example, if you are saying, say, there's vote padding is fraud.
Yeah.
Even under normal civil procedure, who allege fraud, you have to particularize. And the burden of proving fraud, even in civil matters, any balance of probabilities, a core higher than that. But in technical matters, I won't go too much. But at this point in time, in Kawu petitioner, what prove was them? It is time, wow, my lord, make I say the 5 witnesses, my paper, me dinner court, ma come, ma casta, ma get the main, I close my case. By the time I walk out, I say, we will advance of evidence, so we are now back, but catch the court and say, once one force responded, Mr. Ura boxing, who pursue bill case, back. Now the evidence for fraud bar. Naturally said, yeah, we are first, one cast will say, I'm so. That's why I didn't know the SMB of you. Until I had done here, the petitioner on himself will make a case. Or Bressa, yes, and put you be in the box. So why would you quit doing back court to say, Sebi, will be up to Udunano? So why your evidence we are? I think now who complains. I think I was say, they say, by now evidence are well lead, Assembly be booty. But woman, I will press say, young forcing and say, you be defending.
Asempa FM.
And you, sir, and you can't, I will assume an idiom, as so the idea propaganda wabonting, and as so the original court to be proven. The union catch of supporters in Nara, near back court won't say the prove why. The original address is back up near their court in the back.
The final question, and you gave an indication, sir. Monsomo side no more consider. I don't know if this is here. My finalize here. Says a basse or mono a subpoena. Your friend is saying witness for the first respondent. Now Monso move pushes a petition and anchors and so met in a box name.
2011, you call a petitioner, Alhaji Dr. Mahmoud Baumi, or non-casa full box.
Yes.
Or the pink sheet bear 11,000 a buy. Utumbre, no atreci. Utumbre, no atreci. Utumbre, no atreci.
Asempa FM.
Obi answer Dr. Farijan say on full box. Now Farijan who says one full box then defend the Juma wire at the end year botiano. And we and judges no so back I much 5-4 because a substantive case had been made. You NDC for buy. On better box, someone will be so say, moving seat when cross a man famba. Results crowd here was a man famba. I can't say near you also work close to case. The young force will be my number, and one could also could be a case back. And 2 levels. One, I was able to meet the threshold for reopening your case. Would I am fan saying your mayor or madam to me meet the threshold for reopening on case or then they will come to the second thing, say, on per se, the issue subpoena and mouth. And that's a court registry issue subpoena.
Yes.
If the principle is allowable, say, will be aware closing a case in an instance where court no will release a wound to me enforce a party into the box. Court no, would the assembly council, court no, the council. A yadea mrama who can say, or to me subpoena ubia. A party to the case or elected say on floor box no now person supino any beating them. The court no case mrama ukwan say na nature say mraso ma ukwan say yes you to me supino you John Dramani Mahama the petitioner. There are lawyers on our side who are strongly urging on the legal team say you who say mrano support this but asem ka keke yem fan say mrano support this na say it me could do what they are and yes so we see issue supina for you John Dramani Mahama, no better than the calculator sentence. Now, yes, we put to him. And it's under consideration. But first, there's a threshold that was already can cross about whether or not sabi utumi bi okay at say ya obi close in the case no ya train obi close in the case obi
yeah
they say obi close in the case what are the extraordinary circumstances here is a mau there consideration now yes your lawyers ni bi you know the enfan kwa ni man say yinjai
Kojo me na say bibia ni ebesia ba bedi nkomo bio
ya me kan hold me that say
great lawyer Kojo upon Nkrumah, a spokesperson for the second respondent and also information minister designate and member of parliament of Wasia Yere being the Eastern region. What we'll do now and it's yebe petitioners and so spokespersons one who akodi nkomo ba ansa na no yebe dane ye ho aba ansa ye ba na ye ne petitioners and so spokespersons ni bi edi nkomo on the way forward for